Hafa Day, welcome to the Guam Congress Building, and good morning, everyone. The Committee on Health, Land, Justice, and Culture is now called to order. Today's Tuesday, February 27th. It's 8:32 a.m. In compliance with the open government law, notices for this public hearing were published in the Guam Daily Post and posted to the Government of Guam public notice portal on Tuesday, February 20th and Friday, February 23rd. Notices were also sent by email to all senators and all main media broadcasting outlets, and this hearing is being live streamed on the Guam Legislature's YouTube channel. Individuals testifying shall first be recognized by the chair before speaking. Please state your name for record-keeping purposes before testifying. We have one agenda item this morning, that is Bill number 240-37 COR, introduced by myself, Therese M. Terlaje. It's an act relative to effectively distributing and disposing of undistributed child support funds at the Office of the Attorney General by repealing sections 34111B and adding a new 34401, 34402, 34403, all of Chapter 34, Title 5, Guam Code, annotated. I'd like to acknowledge the presence of Senator Joseph Augustine, Situsmasi Senator, Appropriations Chair. And I will begin. As primary sponsor of the bill, I will introduce the bill briefly. So this bill was introduced at the request of the Office of the Attorney General of Guam, and I want to thank members of the Office of the Attorney General of Guam for being here, as well as, of course, the Attorney General himself, Situsmasi. The purpose of the bill is relative to distributing and disposing of undistributed child support funds at the Office of the Attorney General. The Child Support Enforcement Division of the Attorney General's Office collects funds from non-custodial parents in accordance with local and federal regulations, distributes the funds to custodial parents for the well-being of their minor children. In cases where the custodial parent received government assistance through the Temporary Assistance of Needy Families, or TANF, the funds may be reimbursed to the Government of Guam. However, there are unclaimed funds as parents have passed away or failed to maintain their bank account information for direct deposit, or failed to update their contact information for the Child Support Enforcement Division to contact them. There are also funds where the bank holding the funds was unable to provide a proper accounting to identify who is entitled to them. As of June 30th, 2023, the total undistributed funds were $6,223,252, of which $4,228,099 have remained undistributed for more than 5 years. This legislation aims to establish a procedure for a more efficient distribution of undistributed funds, or for the transfer of such funds to the Government of Guam and ultimately to the Office of the Attorney General. So the different sections of the bill, we repeal 34111B, which is an existing mechanism for escheating the funds to the Government of Guam after a 2-year and a 5-year period. That will be repealed. In its place will be a new proceedings for depositing undistributed funds if custodial parents or non-custodial parents cannot be located. This will be a petition filed by the AG. And notice will be given again for 60 days, and parties will be allowed to come to court to say why, give a reason why undistributed funds should not be distributed to the Government of Guam. This notice will be published in the daily newspaper, on the AG's website, on the Government of Guam's central website for 3 consecutive weeks during the 60-day period. And it will be posted for 4 consecutive weeks on the public bulletin boards in Agatna, and the courts will be the ones to maintain jurisdiction and resolve any disputes and distribute the funds accordingly. We also add a new section 34402 for case closure and escheatment of undistributed funds, notice of custodial parents and non-custodial parents with active cases. If the division has lost contact with a custodial or non-custodial parent, they will spend at least 6 months to locate them when money is collected pursuant to an order of support and has yet to be distributed. If the funds are unclaimed for 2 years, the AG will begin closing the child support case by sending a closure letter via certified mail to the custodial parent or payee at their latest address. If there is no response within 60 days, case will be closed and any collected funds will be returned to the non-custodial parent. If non-custodial parent cannot be found, escheatment proceedings under 34401 will be initiated. We also added a provision that the funds escheated pursuant to this chapter are appropriated to the AG's Child Support Division to cover the reduction of federal funding. That's my introduction of the bill. I'm sure we will hear more from the Attorney General's office. We did receive a fiscal note on this bill from BBMR. The Bureau notes revenues gained from the escheatment of undistributed funds will reduce the OAG's future claims for program administrative costs. The OAG estimates that every dollar that is escheated will reduce the amount of federal funding being claimed for program administrative costs by 66%. The Bureau notes that there will be additional costs to the OAG specific to the escheatment proceedings to include filing petitions, court orders to appear and show cause, publishing in the newspapers, and other associated costs. The Bureau further notes that existing language already allows for the escheatment of unclaimed child support payments following a separate 2-year and 5-year waiting period. However, with the proposed deletion of that section in the bill, the new sections will replace that mechanism. BBMR notes that by current statute, the amount of $4,228,099 in undistributed funds, which have remained undistributed and unclaimed for more than 5 years as of June 30, 2023, should be escheated to the government of Guam, pursuant to the existing 34111B. All right, with that, I'm going to open it up for testimony, and I'd like to recognize the Attorney General of Guam, Mr. Douglas Moylan, and if you could introduce your team, or please.
Afide, Madam Speaker and Senator Chairperson San Augustine. To my left, I have Raymond Ilagan, who's the Deputy and 4D Director of the Child Support Enforcement Division. To his left is Frankie Palomo. To my right is Yolanda Elliott, going on with Rhea King and Wilfred Affligui. I am the Attorney General, Madam Speaker. Thank you. So, may I make a brief remark?
Yes, please proceed.
Thank you. At the AG's office, Madam Speaker, ever since I was the first elected AG, the undistributed funds has been a problem with our office, that monies that are collected are not distributed to the custodial parent who's entitled to the money, primarily because these parents become unlocatable. For the highlight of this testimony, and I'll defer much of it to Ray Ilagan, the deputy that knows all the logistics of it, there is a group of monies within the amount that nobody can identify. This is over, I think, 20, that's actually probably 30 or more years that has gone on with the AG's office conducting child support operations, being put into a bank. The bank's records, from what I understand, have become so skewed, or a bank closes, that tracking who was entitled to the funds is no longer capable by the AG's office. Obviously, and I think at least when I came in 2003, there is tracking that's available for it, and we have those funds. So, I guess make no mistake, Madam Speaker, that I am for getting the money directly to the custodial parent and the children that are entitled to it. The problem is, logistically, we're holding on to funds for such a long time that we're no longer capable of identifying who's entitled to it. So that's how we began this. It's become a debate issue at every AG's election now about how these monies have not been able to be distributed. Since I took office, I assigned 3 very experienced investigators towards fulfilling the job of finding the parents and getting them their money. So at that, Madam Speaker, may I defer to Ray Ilagan to have further comment. Thank you.
Thank you. Mr. Ilagan.
Good morning, Speaker Terlaje,
Yeah, turn that on.
and Senator San Augustine. My name is Raymond Ilagan. I'm the Deputy Attorney General for the Child Support Division of the Attorney General's Office, and I'm in support of Bill number 240-37. I've been with the Child Support Division since 2016, working the establishment and the enforcement of child support cases. I've only been in charge of the Child Support Division for the past year, and I did not realize there is so much more to know about the child support program than actual casework. I had to familiarize myself with the federal program and all aspects of how this federal program operates. Even now, I'm still learning the process. However, one of the many things I aim to resolve is what to do with the undistributed funds. I believe that money that has been collected by the non-custodial parents for the support of their children should be paid to the custodial parent. Unfortunately, sometimes there are issues that pop up: change of custody from the custodial parent to the non-custodial parent, discontinuance of services from the custodial parent, change of address of one or both of the parties, bank accounts closed, etc. These have an effect on the disbursement of payments at the Child Support Office. The undistributed funds issue was not created overnight. It was the culmination of decades of these issues that were not properly and timely resolved. It has resulted in millions of dollars that are just sitting in the Child Support Trust Fund. As I have indicated to Attorney General Moylan, I believe that money that has been collected by the non-custodial parent for the support of the children should be paid back to the custodial parent, or in the alternative, refunded back to the non-custodial parent. My staff has been diligently working to resolve some of these cases. Back in November 2023, the Child Support Enforcement Division started pulling up all the older cases. Fortunately, we were able to look at these cases and distribute about $391,000 to the custodial parent or refund it back to the non-custodial parent. Our office just needs more time to look at these older cases to see what can be done and to properly distribute these funds. But we are working on them. However, CSID has already determined about $823,000 cannot be reconciled. This represents payments prior to August 30, 1996. The State Disbursement Unit has determined that the rightful owners of these payments cannot be ascertained. Lack of bank records from Citizen Security Bank and Bank of Hawaii have made it impossible to account for these payments. So escheatment of the $823,000 may be proper in this situation. However, there is going to be a financial impact on the Child Support Enforcement Division. Should this money be escheated to the government? Any funds that are escheated to the government of Guam is considered income to the government. And as a result, the federal government, who finances 66% of the Child Support Division, will reduce their funding for administrative costs accordingly. I believe that is why prior attorney generals were reluctant to escheat undistributed funds because of the financial impact to the Child Support Office by the federal government. I think in order to safeguard the operations of the Child Support Office, this escheatment bill has to protect the Child Support Enforcement Division from any devastating financial impact by the federal government. With regard to the bill itself, I just want to make one correction. On page 3, line 3 and 4, where it says the AG's Child Support Enforcement Division has undistributed funds totaling $4,814,000 as of March 31st, where current efforts are being made to locate the custodial parent. It should read, as of March 31st, the AG's office has undistributed funds totaling $6,239,576. Collections remaining undistributed more than 5 years is $4,199,490, where current efforts are being made to locate the custodial parent and the non-custodial parent. It was my error in the calculation when I was trying to assist in drafting the bill. But I did provide the numbers to correct that. Thank you.
Excuse me, Madam Speaker, but anything that any of you in the panel is going to say, if you're reading it from a written script, provide that to us so I can follow along with you, because I don't have any information on what you just stated.
Okay.
You want to talk about money? Let's talk about money.
All right.
Okay? I think I'm pretty good at that part. Okay?
All right. I apologize. I will have that to you.
If we could get copies made. All right, thank you. All right, is there anyone else who would like to testify?
Huh? Okay.
Is there anyone else who'd like to testify? What's this? I don't know what this is. Okay. Is there anyone else? Okay, if not, then we'll open it up for questions. Okay, so the Attorney General is able right now to do proceedings to escheat the money, but they've just hesitated because of the reasons that you've stated?
Correct.
Okay, and is it correct then, what BBMR said, that if the government, if we do go through with those proceedings, what is the impact per dollar on the Attorney General's receipt of federal funds?
The way I understand it is for every dollar that we escheat to the government, it's going to have an impact of 66 cents to the child support.
66 cents,
So it
okay.
gets reported, yeah.
All right, but do you think we should go ahead with it regardless?
I think we should go ahead with money that we can identify that we can't locate any of the parties. So currently, as it stands right now, as of today, there is $823,000 that we just don't know where it goes. So that one, I think, would be safe to escheat. I think in our analysis of how it's going to impact our office, I think we may want to break it down into 4 different escheatment periods. So we divide it by 4 and we distribute 1/4 of, or try to escheat 1/4 of it and see where that takes us. That way we can, if there's some issue with our funding, at least we can try to control the damage to our office.
All right, that makes sense. Is there any possibility of, instead of the money going to a custodial or or reimbursed to the non-custodial parent, can it go to the child if the child is 18?
Well, the issue that I have is we can't make that decision ourselves with regard to who is entitled to the money, because it's really a probate issue. And so if the money is rightfully belonging to the custodial parent and the child comes forward, if there's several children, then all the children would be entitled to it. If they have a surviving spouse, that part of that money should belong to that surviving spouse. So it's a question of how the probate law is going to impact. If legislation is included that they can come forward and make a claim for the undistributed funds as the ultimate recipient of the child support, then I think legislation could be drafted so that we could include that.
Is the amounts when a non-custodial parent is ordered to pay, is that tied to a child, like a name?
It is tied to the children that are named in the case.
Okay. So I would like to consider that, if that's something you're willing to consider, to allow language that allows a court that if we can find the child and they're 18, that we just allow the courts to give it to them.
Yes, and Madam Speaker, another consideration for the legislature is that in that $800-some thousand that we cannot account for, if the legislature wanted to build in a provision that somebody actually makes a claim, because we probably have the court file, and that if it's justified that although the money would escalate to the government, that they would have a claim with the government of Guam to get that money. So that would account for people that for whatever reason, they weren't part of this notice period, and then they claim part of the 800,000, because we can identify those outside the 800,000. It's just that logistically we can't get a hold of them. And this is always that problem with the SGET funds, and we've had it in the office where people in bank accounts, the government actually gets the money. They have to go to court to try to get that money that was taken, but the courts say that because of the SGET provisions, the government of Guam cannot give you your money back, even though they've claimed and they've shown that that was their money taken from their bank account. So if the legislature wanted to build in a provision for the 800,000, so if they make a claim and are able to prove it, then the government would pay it out as a government claim.
Okay, I'm willing to do that with your help. The other question is, could you just explain to us where these funds are held and who has control over them? Is it one bank account, a trust fund, as you stated, or are the ones that the 800,000 Bank of Hawaii, you said, are those because you put them into direct deposit already and now we don't know the owners of the direct deposit?
So all the money that comes into the child support office through payments from non-custodial parents is paid into one trust fund, and currently that trust is held by Bank of Guam.
Okay, so all the money we're talking about would be Bank of Guam.
Correct.
All right. And the 4 million is, okay, so or 6 million now. Well, he's claiming that as of June, 4 million could be escheated already. It's
Yeah.
met the
Well,
the
it's been
deadlines.
sitting there 5 years or greater, so it could be escheated, but I think our duty is to make sure that we try to contact either the custodial parent or non-custodial parent. And that's why initially when AG Moylan took office, he assigned the investigators to locate the parties. And so that's the main goal, is to try to find the parties to make sure that the money goes rightfully to them.
Okay. Is there, so we have a escheat to the government and then appropriate it from the government to the Attorney General's Child Support Division. Is there such a thing as just escheating straight to the division?
If legislation is created that way, I think so. So that way the money just stays in the trust fund, and then once the court makes a judgment that this property is cheated, then we can just take it out of the trust fund and pay it to the general fund for our operations. I think that's how it works.
So there would not be necessarily a windfall to the AG's office, like extra money, because they're going to cut your by 66 cents.
We're just trying to make sure that our office is fully funded to continue its operations.
And Madam Speaker, I asked Ray to make sure before we asked this bill to be introduced to get the actual federal communication and statute or regulation, and as part of our letter we attached it to it. So we confirmed that the federal Region 9.
Yeah, Region 9.
Clearly they were posed with the question, they says no, it must go back to the child support operation, otherwise it'll be reduced from the amount that they give to the government of Guam.
And if it goes to your division, is there a reduction in your future funding?
There'll be an offset.
Yeah, so whenever there's a judgment of escheatment, we have to report that to the federal government in our claim as income, and then the next quarter, their funding is reduced accordingly.
Okay. So no matter who it goes to in the government of Guam?
Yeah.
Yeah, all right. And then, all right, I guess that's it for my questions. Senator San Augustine.
Well, thank you, Madam Speaker. As you identify the amounts, can you identify the years, when it reached the 2 years or the 5 years? Because you're talking 800,000 is already beyond, well, when did that happen? And the reason why I ask this is because there may be some non-custodial parents that are still paying. And the child that it's supposed to go to, I mean, they've called me directly. They said, my daughter's already 25 years old and she still hasn't got any money from her mother. Okay, let's make the claim that you can't find the mother. But it's quite evident you know who the child is, because that's part of the court order. And if you're saying then that the law doesn't require them to get it or get access, then maybe we'll just make that change also. And then at the same token, what is the process when a non-custodial parent must make payment? What is the restriction? They can't get their passport, right? Their taxes, income taxes is grabbed.
Correct.
And what bothers me about that is that, okay, it's been, if there's a proper tracking of the child, that is why, I mean, that's why it's called child support. It's not for the mother or the father. It's for the child.
Correct.
Okay? If the child already reached the age of 18, why is there still a freeze on their passport? Why is there still, I mean, I'm just trying to understand. I mean, okay, there's an arrears, fine, catch up and finish it off. But at what point do you determine when it needs to end? Because you're talking about money that's sitting in the bank that should go back to the non-custodial. And I've asked this non-custodial, it says, have they ever called you about that the money never got there? And says, no. Have they ever wrote you a letter? No. And I have to fault the system is that, wait a minute, you're still getting the money. And I know you're getting the money because they're 1040. It's being tagged already. You're getting the money, so the excuse of not able to reach them, that's not gonna hold. That's not gonna hold at all. And I have no problem supporting child support, because if you look at the budget in the past, we did carry over to make sure that child support stays alive. I'm in support of that. But I believe the money needs to first go back to if you can't find the custodial parent, the next step should be to the child. Because the child may be suffering today, because for the past 5 or 10 years that the non-custodial has been paying, that parent has been, that child has been struggling. And I believe they're still struggling. But it seems that nobody wants to reach out to the child. And I'm not saying you should, but I believe you can.
Right. The system, Senator, is exactly what we would like to have done. I think that would be an excellent idea.
Well,
and then child or children, break it up equally among them.
Well, then in this bill, instead of just you, because I have no problem supporting the Attorney General's office in that area. But I have a problem with, if we report there's cheated money, then it's going to reduce the child support. I'm not in agreement with that with the federal government. No. You continue to give the grant for what it was intended for. And if we have to change the verbiage to move that money to help you, because it's not only child support you need to take care of. There's many areas, I know in the Attorney General's office, you need help. And I don't want to use the word to say, let's move this money to, it's cheated. But
So
then,
you would take it and then put it into a special account for the government to just clear up the ambiguity and just keep it by the government in an interest-bearing account somewhere. Give us the mechanism and the requirements to locate them like we're doing,
that's correct.
but put it in a special account so the federal government won't say that it's escheated.
Exactly. I don't want the federal government to start saying, well, you've been getting is cheated, we're going to reduce your funding. Come on, federal government. You print your own money. We don't. And I want to make sure that we protect child support, because at any given time when you have to locate people, I understand that. I'm a former police officer. Locating people sometimes is very time consuming. And it'll reach a point where it's like, they're not here. But then later we found out the only reason why we can't really find them because they're not working. They're doing, those sideline jobs. They don't want to pay taxes. Or they're just not recorded anywhere. But I know in the system, if I'm correct, I think the child support got a program where you can find people pretty much anywhere in the United States. Am I correct? I see heads shaking back there that yes.
Yes.
You guys have a system. And that was what we continue to carry over to keep the funding in the past, I think, 2 years, to make sure that child support is still alive, child support division is still alive. And I want to make sure that you guys still stay alive. Because I'm not going to say it, but when they used to put in news, deadbeat fathers, no, they're not only deadbeat fathers, there's also dead mothers. They're on both sides of the street. They're not just one side. And I want to make sure that child support is able to get it If it's not to the custodial, then to the child, and if at the end of the day, you know where you're getting the money from, there's no doubt. I mean, you can call revenue tax, they'll tell you who we deducted to send to you.
Yes. You know, Senator, you raise a very good point, and I know that over the decades that I practiced in the child support court, the judges, you hear a lot of parents complaining that, hey, the mother or the father is getting the payments, but the money isn't going to the kids. And the judges usually kind of defer to it and say that, well, the system is set up so the parents get the money, the custodial parent gets the money, and they got to deal with it, sort of thing. They just ignore that. If you put a requirement in the statute, like Ray is indicating, that for these monies, the children have a direct right of claim, it will help clear up the money. And that court order that you were referring to, the judge issues an order and it identifies the children that the child support order is covering. Just divvy it up among the child or children equally. The legislature can do that.
And that's what I'm looking at in this bill, because helping the Attorney General's office, you're not going to have any real problem with me other than where am I going to get the money, okay, in the budget. But I don't want the federal government to start saying, we're going to reduce nangananza, you print the money. You just keep it coming, because we still need help. Okay. And then we figure out a way, and maybe change the verbiage here, Madam Speaker, to direct the court. No. The kids, that's why it's called child support. It's not mother support or father support, it's child support. Make sure that kid has it. Because like I said, I've gotten calls from quite a few non-custodial and said, I've been watching my daughter before she turned 18. And I know for a fact, I'm still being deducted, I'm still paying, I still can't travel because there's a restriction, passport restriction. Maybe that needs to be reconsidered to lift that. I don't know, I'm not too sure exactly what are the rules of engagement that the Attorney General's office does, but we need to figure out a way how to, if the non-custodial needs to fly to work, let them fly. Let them get their passport. Because maybe that's the only way, because you can track them. You got a Social Security number, you know where they're making their money. Yeah. They're going to have to file somewhere. And if they try to disappear, they're going to have to come back. The U.S. citizen, they're coming back. When? It's like an open warrant. When you enter, we got you. You know what I mean? And that's just how the system works. But with that, first option I would support is number one. It's not identified as cheated funds. I don't want you to lose any money. And let's figure out a way how we can change the law to make sure the child gets it. And the non-custodial, the people of Guam, please be listening. If you're a non-custodial parent, get on the wagon and get to the Attorney's office and say, where's my money at? And if it's not going there, I want to make a claim. Because when we fix the law that the child will get it, non-custodial, until that amendment is made, I don't believe you should be entitled to it. Because your child you are paying for needs to get it first. And if the child, if the non-custodial or the custodial passed away and the child, there's quite a few kids that have been passed away, what is happening with the money? Give it back to the payee. If not, let's put it in some program where we can help not only the Attorney General's office, but everywhere else. Like we had yesterday, we had the hearing on GMH. We're funding a deep hole. And I don't want the Attorney General's office to get in a hole. Keep you afloat, keep you going, and do what you need to do. Thank you, Madam Speaker.
Thank you, Senator
Could I just,
yes, Mr.
Could I just make a comment on some of the remarks you made? Yes, I understand all those concerns that you've raised. It's been raised in our office several times. Part of the problem with regard to the arrears, let's start off with that. Sometimes the custodial parent applies for services. However, sometimes it's a referral from the government of Guam for TANF. So whenever the custodial parent applies for government assistance and the Department of Public Health issues them like a check for $600, $700 a month for support of the kids, our office is obligated, once we get that referral, to make a collection on child support. And so in a lot of cases, the money doesn't go to the custodial parent. It goes back to reimburse the government of Guam. That's why the child support office was initially created to begin with. So there may be, in situations, two payees that are of concern. One is the reimbursement for public health and the custodial parent. And there are rules on how the money is distributed accordingly. So if she's like for instance, the custodial parent applied for services and she was a previous recipient of government assistance, if there's a current child support payment that was made and she's not on government assistance, that money goes to her. However, if she remains on government assistance, that money goes to the government because she shouldn't, I guess the word is like double dip. She can't apply for money and then get the child support. It doesn't work that way. So there's instances with that. Just a second comment on the arrears. Sometimes custodial parents continue to pay even after the child is 18. A lot of times in these situations, and a lot of times you just go to court for monitoring of payment. We have to get these individuals, the non-custodial parents' jobs, so we try to encourage them. Now we have a system in place with the Department of Labor so the court can order them to apply for service of the Department of Labor. But unfortunately, what happens over time is the custodial parent has to figure out a way to support the child. And so a couple years may go by, sometimes 5, sometimes 10 years go by, and not a dime is spent by the non-custodial parent to the custodial parent. And there's an existing order that is in place that the non-custodial parent is obligated to pay. So those are arrears that accrue. And unfortunately, in situations where the child is now 18, 20, 25 years old, that money is still obligated to the custodial parent because during the time when the child was a minor, she had to cough up all her money to support the children. So that is some of the issues that our office is facing. With regard to the children I know you said make the court order that the children are entitled to the money because sometimes maybe the custodial parent doesn't use the money for the kids. It happens all the time. Unfortunately, our office doesn't have the resources to monitor that, and so that's why I think the court orders that it goes to the custodial parent on the assumption that they're going to do what is right and provide for their children with the use of that money. A lot of times, it may not happen that way, but I don't know if our office will have the staff if we have to monitor where every dime went for that child. Food, clothing, shelter has to be provided by...
Well, and that's why I'm referring, instead of it's cheated funds, let's figure out a way how to get it to you
I see
so
what you're
you
saying.
can do that.
Yeah, I see what you're saying, Senator. At some point, we need to bring closure. And letting the kids get it once they hit 18, because the mother sat on her rights, didn't move forward, or we couldn't look, whatever the situation was, I think we just need to bring closure. So I would inform the senators that if you wish, I will work with Ray to make some revisions pursuant to the conversation we're having here for proposal and consideration by the legislature.
Yes, thank you. And also when you talked about like public health, right, when they apply for assistance.
Yeah.
I'm just concerned is that maybe if you get assistance so that you make sure now that the bill that public health wants you to pay under the child support is legit. I'm not saying it's not, but a non-custodial or a custodial may go in there and says, I need assistance because I have 4 kids, but none of the 4 are living with her, but she claims she needs the assistance. I'm just very concerned about that because realistically, some of our people, you know, I hope they're honest, but you don't know until you find out that they're not.
Correct.
And then they're asking AG's office, hey, you need to reimburse us because they applied for assistance. And then you find out, I mean, you know, like I said, they help your office so that when somebody wants to make a claim, well, okay, they're living here, okay. You know, and your investigator goes, you know, just what's the home visit? We're just double checking that your kids are here. It's under the child support. You know, and you'll find out. Then you can tell public health, I'm sorry, but we're only going to reimburse for so much because this is all that's there. Let public health figure out their mess. Because, you know, sometimes when you fill in a form, you say, yeah. You don't realize what you said yes to until you get caught.
Yeah.
And I'm supporting what you're saying. I'm just saying we just need to clean it up a little bit better.
Oh, yes, and if I can just make a comment, it happens all the time. I've dealt with cases where the Department of Public Health makes a referral. We filed a complaint, served the non-custodial parent, the quote-unquote non-custodial parent. They call into court for the hearing, and the non-custodial parent and the custodial parent turns out that they're actually living in the same household. Our office can't proceed on those type of cases. We will move to dismiss the claim from the Department of Public Health because he is not a non-custodial parent. He is deemed a custodial parent for purposes. So there is a mechanism, but it has to be based on the parties telling us the information. If the parties don't participate in the court proceedings, then we can't correct the situation. If we go into the first initial hearing and the non-custodial parent says, oh, she doesn't have the kids, it's the grandma that has the kids, we will do our investigation, we will contact public health, and we will report that she may be making a
false claim.
Yeah. So it does happen. Our office is aware of situations like that. Not too many, but there are situations where it does happen. I had one where I called up the non-custodial parent to find out information, and all I can hear is he turned around and talked to his wife. I told you not to apply for TANF because we're still together. And so things like that happen.
But see, at the same token, it's like sending money to a custodial parent, and the parent already left to the States. She's got the account. She's still getting the money. Where's the child? On Guam.
Correct.
It's currently happening today.
Yeah.
They're not applying for assistance. They're just getting the money. And then you know, like I said, I've got call from non-custodial and even kids. They're already adults. They're not kids anymore. They're like 25, 26. I'm like, half a night girl or half a night dude, you didn't get the money. No, my mom is in the States. I've been living at my, yeah, that's what I'm concerned about.
Okay.
Is that these kids are trying child support, nothing else. But anyway, we're good. I think the Attorney General is going to work with the Speaker, and let's come up with an amendment so we can work this, because I want to find a way to help you guys. And don't identify as cheated. Let's figure out a way where we can put it somewhere, and then we can get it back to you. Maybe not everything, but a big enough chunk so that you can stay alive and you can keep doing not only child support, but everything that could be related to child support.
And Senator, let me assure you that since I've taken over and put Ray here, I get WhatsApp messages, and we have a direct action message portal on our website where they're saying exactly what you're saying. Hey, I've been paying this. That's why Ray has been personally involved in a lot of these cases, and I welcome every senator here to send it to me by email, and we will have child support address these issues, because there's just so many child support cases that it requires us to kind of take a look and reevaluate it, like Ray was kind of mentioning. And we do have the staff for that. So I welcome any of these particular cases to be sent to us, to me.
Okay, and if you can check also your rules on the passport. I put for both, all it says is that you cannot get a passport. Put for both, have some leniency where it may be going for an employment to continue paying child support. And if you keep restricting that, you're never going to get money, because they probably can't get a job here, but they can get a job in somewhere else, because the system can still catch them.
Well, with regard to the passport, these are federal regulations that we have to comply with. However, our office has discretion on when to release them. So in situations where it's for employment purposes, they just need to come in and tell us and provide us information. And our office does release passports for purposes such as work situations.
Employment or medical, all right?
Medical.
Okay.
Yeah,
I just want to make
especially
sure.
for medical. I mean, I don't want to deprive someone of medical need because they can't get the services at GMH, and then something happens. I don't want that on my conscience. So it is an issue that we have addressed. We have released passports based on medical needs. So they just need to tell us.
All right.
They don't tell us.
Thank you.
There's nothing we can do.
It's an effective stick when the person can pay and isn't paying, but I know Ray is always soft-hearted sometimes, a little bit too soft-hearted in my opinion.
All right. Thank you, Ray, and thank you, Attorney General. Thank you, Madam Speaker.
Thank you, Senator Sinoxy. All right, I just have a couple more questions. So we mentioned interest. Is this a trust fund, an interest-bearing account?
Yes, it is an interest-bearing.
And are you able to use the interest?
It's very small.
Oh.
However, I think we do report that as income, right? Yeah.
Report it as income to the Attorney General's office, and that does not affect your grants?
It does a little bit. The interest is not that much, so it's not really, it doesn't really have an impact.
All right, is there are your funds, or is this the fund that was subject of a transfer, like an unauthorized transfer in the past? So we've put in special to protect that, so it's not transferable?
Correct.
Okay, and then, so most of these are because of federal guidelines. Is there any way to get an exception for Guam or something like that?
For the passport issue?
No, for the escheated funds.
Achievement? No, that's the mechanism that the federal government has in place, that if it's considered income, then to the government of Guam, then there's the,
All right, so
Process.
other states have the exact same issue?
yes, the other states have the exact same issue. However, Guam it may be a little bit different than that because the other states have been escheating small portions through the years.
I
So
see.
it doesn't have an impact on them.
Okay,
Unfortunately, Guam hasn't done it, so now we just have this large lump.
all right,
sum.
so as written, or we're going to, before we move forward, confirm with your office, you can confirm with us whether the bill as written allows you to do the escheatment on kind of periodic, as you testified, and whether we can add language that would allow the courts to give it to a child who had turned 18, who was neither the custodial or non-custodial parent, but the child himself who was entitled, or who that money was being paid for, something like that, that kind of language. I had written a draft with that, but was not clear, so didn't do it.
Yeah,
I would,
so with regard to the bill, I mean, there could be a separate section not considered as escheatment, like the Senator San Augustine was saying, that we just have provisions in there that proper claims for the money in the undistributed collections could be made by the custodial parent, non-custodial parent, or the child, and we specific before the process of escheatment even
Okay.
begins. So that way, there's no considered income to the government of Guam that's even being
all
considered.
right,
So I do
so
understand.
that
what
would be
you're saying.
prior to the court then? That
Correct.
would be, you could do that yourself if
Yeah,
we put that in?
just need
Okay,
legislation
great.
for that.
And then, all right, I have no other questions. Attorney General, did you have anything else?
No, we just very much appreciate, Madam Speaker, your having introduced the bill, and Senator San Augustine for your very good comments on how to handle this matter. We thank you.
Thank you, thank you. Thanks to all of you and for your continued work for the children of Guam. Sidus Masi. There being no additional individuals to present testimony, this committee will consider Bill number 240-37 COR duly heard, and the time is now 9:19 a.m. Public hearing is now adjourned. Sidus Masi.